The unintended consequences of adding a name on a deed. A deed is a document that allows the owner to transfer all or a portion of ownership in property to another person. Oftentimes, people will bypass an attorney and add people on their deed by themselves. Why not? It seems simple enough, right? You can get the form at an office supply store, fill it in yourself, and record it. What can go wrong? Well, you'd be surprised. One unintended consequence is sometimes people add a non-relative to a deed like a boyfriend, girlfriend, or a friend, only to find out that it's very difficult to remove that person from the deed when the relationship turns south. When this happens, you are left with two options. You can get the person you want to remove from the deed to voluntarily deed back their portion to you, and you buy out their interest. Good luck with that, especially if the relationship turns contentious. Or you can engage in lengthy and expensive litigation, and you can get a court order to sell the property, and the parties split the proceeds of the sale from the house. However, the attorneys will get their attorney's fees first, so whatever is left over, that is what you will split. This is called a partition action. Another unintended consequence, adding another person on the deed may result in losing your Florida homestead exemption in certain circumstances. You may lose significant tax benefits when this happens. Another consideration is not adding the precise language on the deed may result in the property transferring to the wrong person. There's a big difference between owning property as co-owners and owning property as co-owners with rights of survivorships. Not knowing the right way to word a deed may accidentally derail your estate planning objectives. Another consideration is not executing the deed and putting the correct language pursuant to Florida law may result in the deed being invalid and of no effect. In addition, once you add a name on the deed, you will not be able to sell the property or refinance unless all parties are in agreement. The parties named on the deed all have to sign the purchase and sale agreement, the closing docs, and the bank documents if you want to refinance. Another consideration, adding someone that receives government long-term care benefits, such as Medicaid and Social Security benefits on your deed, may end up for that person to lose their benefits. So that is something that needs extra care before you add that person's name on the deed. Lastly, if your property is mortgaged and you add an additional name on the deed, you're in fact changing the ownership of the home. This may trigger the due on sale clause on your mortgage, and the bank may elect to call the whole loan due and payable. When this happens, the bank may elect to start foreclosure proceedings against you. Oftentimes, real estate attorneys are hired to correct and fix legal do-it-yourself deeds. Fixing a problem deed can cost thousands of dollars, so you are better off consulting an experienced attorney before making changes on your deed. This is Dina with your legal concept. Hope this helps.